No objection, Your Honor.
Noted.
With that, Mr. McKeska, would you please begin the announcements?
Yes, Judge Drayton McKeska, attorney for the department. Ms. Lewis.
This belong permanency specialist.
Lindsay Ligon, belong permanency supervisor.
Anna Swallow, attorney ad litem for respondent mother, Letha Hines. Ready? Letha, can you unmute and state your name, please?
Letha Hines, the mother.
Thank you.
Deborah Fuller, attorney for the alleged father, Robert Smith. Mr. Smith, could you unmute and announce?
Robert Smith.
Mr. Smith, I need you to turn your camera on, please. Thank you.
Charles Weatherby, attorney for father, Mr. Hatley, who is in custody in Kerr County on numerous charges. Not ready, but not opposed.
Marcus McLemore, Hill Country Costa.
Kendra Sims, attorney ad litem for the children.
All right, we're going to go ahead and get started then. I've reviewed the reports in this case. Miss Lewis, we'll start with yours. There's no any child heritage in this case, correct?
Correct.
All right, and Mr. Weatherby, I know you said you were not ready but not opposed, so obviously I'm overruling any not ready and we're moving forward. And then the permanency goal at this time is family reunification.
Yes.
And that's with the mother, Miss Hines.
Yes, Your Honor.
All right, and the placement in Comal County is still safe and appropriate, meeting the needs of the children?
Yes, it is.
It's in their best interest to continue?
Yes, it is.
All right, and report states that they're up to date on their medical, dental, and vision?
Yes, they are.
All right, and no special services?
Not at this time.
Are they having all their educational needs being met?
Yes, they are.
And the educational decision maker is still the caregiver?
Yes.
Let's talk about visitation with the mother. Is the visitation schedule appropriate?
Yes, it is.
Are you asking for any changes today?
Not at this time.
And the visits themselves are appropriate?
Yes.
And is the caregiver still monitoring visits?
Yes, she is.
That's working out.
Yes.
Okay. Would you say that Ms. Hines is still in compliance at this time?
Yes, she is.
What does she need to do in order to remain in compliance?
Continue her random drug testing with the department with Belong. Also continue her outpatient substance abuse program with Donnie. And then also continuing her individual counseling with Joni and addressing those domestic concerns that were brought up recently.
All right. And does she have a copy of her family plan of service?
Yes.
You believe that she understands what's expected of her at this time?
I do.
And Mr. Hatley was recently incarcerated?
Yes.
Okay. Before he was incarcerated, was he still in compliance?
Yes.
What was he incarcerated for?
Previous charges on multiple charges. I'm not exactly sure that there's a few charges. Would you like me to read them out?
No, if it's former charges, I just didn't know if there was something new that I wasn't aware of. Okay, but as of this time, he's not in compliance?
No.
Was he visiting before he was incarcerated?
I'm not sure if he ended up having a visit or not, but he is getting phone calls weekly with his children, supervised by the caregiver.
How are those phone calls? Are they appropriate?
Yes.
Is Mr. Smith in compliance with his family plan of service?
No.
Does he have a copy of the family plan of service?
I believe April has given him one, but if not, I will email him one.
Have you had any conversations with him about his service plan?
I have not. No.
Okay. So do you know if Ms. Harrison Bader had made him aware of what he was supposed to do in this case?
I believe she did, yes.
Have you had any communication with him at all since you got on the case?
No.
Okay. Where does he reside at this time?
Out of state. I'm not.
When was the last time Miss Hines was drug tested?
She was drug tested last week, but I have not gotten the hair test back. But the last drug test she took that I have back was on 1/23/2024, and she was negative.
Okay. Has any parent in this case fully addressed the concerns that brought the children into care?
Not at this time.
Is it safe to return the children to any parent at this time?
Not at this time.
You believe that this case is appropriate for mediation?
Yes, I do.
Anything else you're requesting from the court today?
Not at this time, no.
Mr. McKeska, questions for Ms. Lewis?
No, Your Honor.
Ms. Swallow?
Thank you, Judge. Miss Lewis, are the children in therapy?
Yes, they are.
And did you actually confirm that with the therapist?
I have called the therapist multiple times. I've not gotten a call back, but I've been able to confirm it with the case manager and the caregiver.
How often are they going?
Once a month currently.
Okay. Do you know what they're working on?
I don't. I'm hopeful to be able to get those notes by the end of this week so we can look at that.
Will you distribute them when you get them?
Yes.
Your testimony is that you think this case could benefit from mediation. Is that correct?
Yes.
Do you plan to conduct a reunification staffing prior to mediation?
Yes, I do.
At this time, mom's visits are supervised, right?
Yes.
What does mom need to do in order to have unsupervised visitation?
Hopefully we'll get that hair test back soon, and we'll be able to have that, along with just addressing those concerns that we had, at the FGC with Miss Joni Chavez. I believe she's on the right track on that.
Okay. Are you asking the court to grant us authority to move towards unsupervised with agreement of the parties?
Yes, I am.
What about overnight visitation?
Yes, if we can all agree to that, I would like that. Yes.
Have you had a chance to do a walkthrough of the home?
Yes.
And did you have any concerns?
No.
And do you know if Miss Hines was able to secure beds for the children?
We as Belong are working on that, for her. I don't know. Hopefully she didn't get a bed yet because we are working on that to get her those 2 beds that that y'all sent us through the message.
Okay. And you also offered generously to help with the mattresses, right?
Yes.
Okay. Outside of drug testing, outpatient, and individual counseling, are there any other services my client needs to be engaged in at this time?
No, just following her outpatient services and the drug testing and the counseling.
Okay. Thank you. I pass the witness.
Fuller?
Ms. Lewis, were you aware that at the status hearing, there was a discussion that the plan of service was not, was developed for my client was not what was discussed at the FGC?
Was not.
Okay, so at this time, my client does not actually even have a plan of service because it was supposed to be developed pursuant to our FGC prior to the status hearing, and it never was.
Yes.
Okay, so my client doesn't have a copy of the plan of service.
Correct.
So what services, you remember what services we had agreed to at the FGC? I mean, you weren't there, but were you able to access that in the case file?
I was not made aware of this, so I'm not sure which services that he is being requested of, but I can look. It looks like we are requesting him to complete his DNA test that he was asked to do, along with being able to prove that he has employment and a monthly household budget, therapy, and just random UAs and hair follicle drug test. And if anything comes back on that, to follow up with an OZAR.
Okay, and do you see anywhere in those notes that there was no agreement about a hair follicle, but he was willing to do a drug test back months ago but it's never been set up, so he's never done that.
Yes,
Okay. And the therapy's never been set up either, correct?
not to my knowledge, no.
Okay. And then the goal was, once he did the DNA testing, which that is, on Mr. Smith, obviously he hasn't done it, but to if he is the father, for him to engage in family therapy.
Yes.
And you said that the children were receiving therapy. When did Ben's therapy actually start? Because it was ordered a long time ago.
It started at the beginning of this year, January.
Okay, but it was ordered at the status hearing, wasn't it?
Yes, I believe so.
Okay, and so does Belong have an issue with that? Because it was ordered to benefit both Ben, the mother, and eventually my client, correct?
Yes.
And so what were the reasons why it wasn't started at the time frame it was ordered?
I was told that the past therapist didn't believe that the children needed the therapy when they went previously. However, I know at the last court hearing, judge made it very clear that he wanted the kids in therapy. So I went back and spoke with the caregiver, and that's when she was able to get them officially in therapy and continuous therapy.
And so at the last hearing, that was November 30th, but you're saying they just started really
Yes,
sometime in January?
per the caregiver, when I spoke to her in December, the counselor wasn't available until the beginning of the first of the year.
Okay, thank you. I'll pass the witness.
Yes, are there any services that you can provide to Mr. Hatley while he's in custody?
Let me follow up with the jail and see if they'll provide anything. I've asked him, and he's not able to get any services in-house there right now.
That's all I have, Your Honor.
Sims,
I don't have any questions, Your Honor.
any other witnesses, Mr. McCaskill?
No, Judge.
Anybody else have a witness they want to call?
No, Your Honor.
Ms. Sims, anything you want to add?
Your Honor, the kids are doing very well. Miss Hadley is on top of everything. Placement is good. Miss Hadley is the one that supervises visitation, and she's reported to me that it's going well. The kids are excited to see mom. The kids relay to me that they're excited to see mom. I have not been able to observe a visitation with mom yet, but I am planning to do that. Hopefully go to the home the next time Miss Hadley takes the kids and see the home and observe the kids and mom. And after that, I'd like to see some unsupervised visits start.
Mr. Colburn? Oh, I'm sorry, not Mr. Colburn. Is it you, Mr. McLemore, on this case?
Yes, sir. I'm here for CASA.
All right, go ahead.
We've observed visits with the mom. The kids are very bonded with her. They love their mother very much, especially Maddie. She's extremely attached to her mother. We recently saw them at McDonald's, and she would leave the plate, immediately come back and sit with her mom, lean her head on her mom. They're just extremely well loved as a family. It was really good for us to see that. And Denise Hadley's doing an amazing job with them right now, so everything's going well.
All right, thank you. Okay, then for the purposes of the permanency review before final order, court finds there's no any child heritage in this suit, but the permanency goal of family reunification is appropriate in the best interest of the children. Court finds that the placement in Comal County is safe and appropriate, meeting the children's needs and in their best interest to continue. Court finds that the children, are up to date on their medical, dental, and vision, that their educational needs are being met, and they're not receiving any special services at this time. Court finds that they're attending therapy once a week, and that is appropriate at this time. Court finds that the visitations with the mother are appropriate, and the visitation schedule at this time is appropriate. However, I will grant the request to authorize the parties to increase and allow unsupervised visits at the point everybody agrees. And of course, if there's not an agreement, we get to a point where we need some court intervention, just let Ms. Greenlee know. We'll get it on the docket. Court finds that it's appropriate for the caregiver to continue monitoring the visits. That Ms. Hines is in compliance with her family plan of service and has a copy of her family plan of service. Court finds that Mr. Hatley is incarcerated and at this time is not in compliance with his family plan of service. Court finds that Mr. Smith is not in compliance with his family plan of service I'm going to order Belong to make sure he has a copy of a family plan of service that Ms. Fuller has had the opportunity to review with him. We need to get that done within the next week or two, 14 days at the outside. Court will find that Ms. Hines tested negative for substances on January the 23rd, 2024, and that her current drug test is pending. As of today, no parent has fully addressed all of the concerns that brought the children into care. And as of today, it would not be safe to return the children to any parent. I'm going to order the parties to mediation. That being said, Ms. Hines, you're doing a great job. Keep it up. Keep up the good work. Proud of you. And then we'll have our next hearing February 22nd, 2024 at 9:30. February 22nd, 2024 at 9:30.
That's today.
I'm sorry. It is today. I'm just looking at the wrong thing here.
And I think that Ms. Lewis testified the children are only receiving monthly therapy, not weekly.
I thought I heard
Once
weekly.
a
Is
month.
it only monthly?
Yes, Your Honor.
Okay. It's April 25th at 9:30. Sorry, I just looked at the wrong date.
And Judge, I would request if the court's inclined that Belong be ordered to staff this case for reunification with my client prior to mediation.
I think that's fair. Let's go ahead and include that in the order, Mr. McKeska. That might shortchange some things. So let's do that reunification staffing prior to mediation as Ms. Swallow requested. And just to make sure everybody got it, the next hearing is not today, and I apologize for that. It's April 25th, 2024 at 9:30. Okay, anything I failed to address besides the admonishment?
No, Josh.
All right. State of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence and drug-free home for your child. In the event you cannot do so, your rights to your child are subject to restriction and or termination. Thank you all for your time and your service. Good luck to you, parents. If nothing further, all parties are excused.
Thank you.
With that, Mr. McKeska, would you please begin the announcements?
Drake McKeska, attorney for the department.
Alejandra Certuche, Belong Permanency Specialist.
Lindsay Ligon, Belong Permanency Supervisor.
Ron Colburn, Hill Country Casa, guardian ad litem for the Grandstaff children.
Kathleen Savage, attorney ad litem for the respondent mother, Ms. Grandstaff. I'm ready, Your Honor.
Your Honor, Deborah Fuller for Joshua Grandstaff. I'm on the line. I'm trying to get a hold of him.
Okay.
Kendra Sims, attorney ad litem for the children.
Amy Harding, Hill Country Casa Supervisor.
I'm going to give it just a minute to see if we can get either Ms. Grandstaff or Mr. Grandstaff in here. And if not, we're just going to have to move forward. Go ahead and move forward. But obviously, if he comes in, we'll take up whatever we need to do when he gets here.
Thank you, Your Honor. I'm sorry about that. They had some issues last time too, so hopefully they can get him on.
All right. Ms. Grandstaff, could you please unmute and state your name?
Yes, sir. Lindsay Grandstaff, mother.
All right, Ms. Abduche, let's go through your report, please. There's no any child heritage in this case, correct?
That's correct.
And children are in a monitored return with the mother.
Yes.
And that placement's safe and appropriate, meeting their needs.
Yes, it is.
Is it in their best interest to remain in the monitored return with their mother?
Yes, it is.
And obviously the permanency goal is family reunification.
Yes.
All right. And report states that they're all up to date on everything?
Yes. Except their cans and psychologicals, they're being updated this month. Tomorrow, actually.
Yes.
Are their educational needs being met?
Yes.
Is Miss Grandstaff the educational decision maker now?
Yes, she is.
Is that in the best interest of the children?
Yes.
And what about their medical consenter?
She's their primary.
Have you observed Miss Grandstaff with the children recently?
Yes, I have. I had an unannounced visit the week before last. And They were kind of heated after an incident with Elizabeth, but Miss Grandstaff, I did observe her demonstrate stuff she's learned in her services. So she did well with disciplining them and talking to them. She was very patient.
Good. That's good to hear.
Yes.
Miss Grandstaff is in compliance according to your report.
She is.
Anything specific that you want to see her do in order to remain in compliance?
Just continue her random UAs and hair follicles. I believe the last one I did on her was on February 16th, and her UA was negative, but her hair follicle was positive for that same thing, the metabolite. But she did provide a note from her doctor for some medication that she's taking that could be the source of that test coming back positive, because the levels are very low.
Okay. How often are the kids going to therapy, or are they still in therapy?
Weekly.
Okay, I thought so. Is that appropriate?
Yes, it is. She also has them in youth group weekly.
Okay. And Alexis is still on Prozac. Is that review up to date?
Yes.
Overall, it seems like things are going pretty well since they've come back to Fredericksburg and they're back with mom.
Overall, they are going well. Miss Grandstaff has been doing really good with them. She's making some pretty positive strides, and she's going in the right directions. It's just the children having a hard time with the adjustment. They're not used to this much structure and rules and expectations that Miss Grandstaff has set, like very strict on them. So they're having a hard time with that. Elizabeth did have to be admitted to Clarity last night because she's showing some aggression that is kind of getting a little bit concerning. So I'm in support of the decision that Miss Grandstaff made last night in the spur of the moment of taking her there, just to ensure she gets the proper care, so she doesn't hurt herself or anybody.
Okay. How long do you think she's going to be at Clarity?
I think they were trying to do an outpatient type of thing with her, but because of the distance from Fredericksburg and Clarity, it was too much. So I think it might be a week or so, but they should update daily on it. All depends on her progress.
And you said in your report that Mr. Grandstaff is in compliance. Is that correct?
Yes, that was also following the last court hearing, where you also found him in compliance.
On the parent sections,
Go ahead.
I was also going off of the last hearing where you found him in compliance as well.
Okay, so you believe that he's working all the services that are available to him and that he's maintaining an adherence to his family plan of service, even though he's at safety, correct?
Yes.
All right.
Also with his psychological, we were trying to figure that out. I spoke with the facility and I spoke with our provider. Our providers are able to accommodate to getting him a phone call, psychological evaluation completed. I'm just waiting to hear back from the facility because they'd never done that before. And the lady I spoke to said she was going to ask around, hopefully in medical, so that they could do something to accommodate to that.
Okay. What sort of contact, not so much the schedule, but what actual contact are the children having with Mr. Grandstaff at this time?
I don't know if they've had contact with him while they've been with mom, just because it's been so much going on. And I know that that's hard for her as well to be having contact with him. Before it was easy when they were with their grandmother because she would facilitate those. So I don't think they've had any contact with their dad. Oh, she's saying something. I think they've spoken to him by phone at least.
Okay.
They've maintained the same if you can hear me, they've maintained the same routine that they've had because I think it's very important. The 3 kids all express extreme desires to have a new beginning with their father in the very near future. They're all counting down the days till they get to make a visit with him and move forward. And that's something that it was important to me to maintain that because I see how important it is to them. Because that's
thank you. Thank you, Ms. Grandstaff. We need to go in order here so that I can get everything covered, but I'll let your attorney or even whoever else ask you more questions about that if they need to, okay? Thank you.
Yes, sir.
All right. Is it safe to completely close this case at this time? Has mom addressed all the concerns, or do you want to continue to monitor her?
I'd like to continue monitoring her, especially because of the children's recent behaviors, specifically Elizabeth. I think she needs that extra support right now.
So it's in the best interest of the children to remain in the temporary managed conservatorship of the department at this time.
Yes.
But obviously, the court will make a finding that the children are safe with mom based on the fact they're in a monitored return. You're recommending it to continue. Okay, Mr. McKeska, do you have questions for Ms. Zotuche?
No questions, Judge.
Excuse me, Ms. Savage.
Yes, Mr. Tucci. What would you like to see from Ms. Grandstaff during this continued time? Is there any other services she needs to continue to engage in?
I would like her to continue her individual counseling.
Okay. And then in regards to the children, is there any other services we can put in place to try to help the kids with this adjustment time?
Yeah, I definitely think Elizabeth needs some kind of intensive therapy. Which is good that she's at Clarity right now because she's definitely going to receive that, and they'll be able to determine whether or not she needs some medications to help with that, and just follow-ups with her pediatrician for med reviews and stuff like that. She definitely needs that.
How long do you want to continue to monitor the children in the placement with their mother?
Well, they haven't been there a full month yet, so I'd like to see at least 3 more months. I'm sorry, at least 3 months altogether. So 2 more months, I'd like to see that.
And you mentioned the marijuana metabolite, but there's no signs anything's affecting Ms. Grandstaff's ability to parent the kids or to meet the children's needs. Is that correct?
Yeah, no, not at all.
Okay. I'll pass the witness, Your Honor.
Ms. Fuller.
Do you think this case would be should go to mediation prior to the next hearing?
I think it would be beneficial.
Pass the witness.
Ms. Sims.
I don't have any questions, Your Honor.
Anything further for the department?
Just a request, Judge, or just a suggestion with regarding Mr. Grandstaff's psychological evaluation. I know they're checking with the facility, but I was thinking that we could possibly use the same language that we use from the genetic testing orders. And if the court orders he complete it with using that same sort of language, then maybe that will encourage the facility to facilitate that evaluation.
Granted, I think that's a good idea. Okay, anything else you want to add, Ms. Sims?
Your Honor, can I briefly call Ms. Grandstaff just to get an update on anything the kids might be needing?
You may.
Ms. Grandstaff, you heard the testimony and been placed back with you for about a month now. Are there any orders that you believe this court could make to help the children adjusting to being back in the home?
Like as far as services?
Therapy, services, anything you can think of that might be helpful for the children.
There's things, yes, we need a family therapist, and then just whatever recommendations that they make for Elizabeth, and eventually Alexis, because, you know, we're working on things with her as well. And I think she's learning a lot from seeing Elizabeth accept everything, and be willing to do what she did last night. And so anything that they recommend, I mean, they were talking about different ranches that she could go to for a couple of months and really just do a major reset, which she needs, you know. And so if whatever comes from that, just the assistance and help getting her into that type of program if that's what she needs.
Okay, and you're willing to continue to look at those avenues and do anything that the children might need. Is that correct?
Absolutely. And there's like a few things like I've asked for help with getting them into the recreational sports. I know that it's about $200 just to get Bryson to play baseball. And by the help of CASA that they were able to do that yesterday. And I was so extremely grateful for that. Depending on what happens with Elizabeth, she's got, I've been taking her out to the Triple H Ranch. I took her out last Saturday and we started volunteering there so that she could get to work with the horses before a summer program comes available. But these summer programs are like, they're pretty expensive. So if there's anything that we could do to help financially cover those extras that, not every kid gets, but, my kids definitely deserve this opportunity to spend the summer,
Thank you, Ms. Grandstaff.
Exactly.
I'll pass witness.
Any cross?
No, Judge.
All right. Anything you want to add, Casa?
Can I ask Ms. Grandstaff a question? I'm sorry.
Sure.
You said that the children have continued their phone calls with Mr. Grandstaff. They've gone extremely well, correct?
Yes.
And they're very bonded to their father.
They are. They're very bonded to the good part, and yeah, and they're working through all the bad.
Okay. And so you think that should continue?
I do.
Okay.
As long as he continues to demonstrate that he's willing to change and wanting to make those changes, and does everything that he needs to do for himself.
Thank you. I'll pass the witness.
Any other questions for Ms. Grandstaff? Mr. Colburn?
There we go. Good morning, Your Honor. I would nothing additional except what was included in our report. But I would like to offer words of encouragement to Ms. Grandstaff. My observations of her dealing with the kids is related to consistency. I know she's establishing boundaries in this difficult period of reunification, but one day she'll look back and realize all the efforts that she put into it will certainly produce healthy, connected adults. One other matter, CASA is somewhat concerned about and think we need to give some attention to whatever agreement needs to be in place upon Mr. Grandstaff's release, as there are no other agreements for marital separation or a divorce petition dealing with custody and visitation issues, and would like that to be as seamless as possible, knowing the kids desire to be completely connected to their dad, and how best is that accomplished?
Okay, thank you, Mr. Colburn. For the purposes of the permanency review before final order, the court finds there's no Indian child heritage in this suit, that the permanency goal of family reunification is appropriate in the best interest of the children. Court finds that placement of the children in a monitored return with Ms. Grandstaff is safe and appropriate, meeting their needs and in their best interest to continue. Court finds the children are all up to date on their medical, dental, and vision checkups. However, they are needing their CANS assessments and their psychological evals to be updated. So I'm going to make sure to order that be done timely. Court finds their educational needs are being met and that Ms. Grandstaff is currently the educational decision maker. Court finds that they are in weekly therapy and that seems to be working out okay at this time. Court finds that Alexis is receiving a psychotropic medication. That review is up to date. Court also finds that Ms. Grandstaff is the primary medical consenter and that is in the best interest of the children. Court makes the finding that the mother, Ms. Grandstaff, is in compliance with her family plan of service. Mr. Grandstaff is also in compliance with this family plan of service. To the extent that services are being offered, he is adhering to his service plan, making progress. I'm going to order that the phone contact with Mr. Grandstaff and the children continues. I am a little concerned about Elizabeth going to Clarity, but I do believe that and agree with Ms. Subtuce that the decision that Ms. Grandstaff made in that situation shows that she has made some progress and some intellectual maturity. So I'm glad to see that, Ms. Grandstaff. I'll find that it's in the best interest of the children to remain in the temporary managing conservatorship of the department, as neither parent has fully addressed all the concerns. And I'll make a finding that I think I already made it, that it is safe for the children to be in the care of Ms. Grandstaff at this time. I'm going to order the parties to mediation. And I want to make sure that one of the things that's discussed at mediation is future contact, as Mr. Colburn with CASA brought up. I think it's a good point. There's no other orders in place, so there needs to be something set forth within the framework of this case. Our next hearing is going to be I almost did it again. It's going to be April 25th, 2024 at 10:30. April 25th, 2024 at 10:30. I have to admonish you, Ms. Grandstaff, and obviously put it in the order for Mr. Grandstaff, that the state of Texas gives parents in CPS cases 12 months to demonstrate that they can provide a safe, stable, violence, and drug-free home for their child. In the event they cannot do so, their rights to their children are subject to restriction and or termination. I think we had Mr. Grandstaff log in actually under calling user. Mr. Grandstaff, if that's you, can you unmute? I don't know, maybe he doesn't have anybody with him. All right, well, if he is here, I think he's heard everything. So I'll see you all back April 25th, 2024 at 10:30. Thank you all for your time and your service. Ms. Grandstaff, I'm really proud of the progress that you've made and everything you're doing. Good job, keep it up. And if anything further, all parties are excused. With that, Mr. McKeska, would you please begin the announcements?
Yes, Judge Drake McKeska, attorney for the department.
Shelley Nix, belong permanency specialist.
Lindsay Ligon, belong permanency supervisor.
Kathleen Savage, attorney ad litem for the children. Your Honor, I'm ready.
Jerry Curry, Hill Country CASA, volunteer and guardian ad litem for the boys.
Amy Harding, Hill Country CASA supervisor.
All right, the children of this suit, according to the report, Landon's 4, Barron is 1 at this time, or at the time the report was filed, and they're currently in a Hayes County foster care or foster placement, correct?
Yes, Your Honor.
And is that placement safe and appropriate, meeting their needs at this time?
It's meeting their needs at this time, but we have another plan in place.
So it's in their best interest to transition to another placement.
Yes, because the current placement cannot be their permanent home.
And the permanency goal is unrelated adoption?
Yes, it is.
Yes.
And let's see here. Children are up to date on their checkups.
Yes, they are.
No concerns there.
No.
And Landon's still on the ABA therapy waiting list.
Yes, he is.
What's the story on that? Like, how long are we expecting that to last?
When Ms. Garcia originally put him on the wait list, I was told it could be up to 2 years. Because we are about to transition to a different placement, I believe that the foster home is already looking into options available in that area.
Okay. And is the current placement the least restrictive placement possible?
Yes.
And anticipating this move, do you believe that the placement they're going to be moved to is the least restrictive placement available?
Yes, Your Honor.
Okay. Any known barriers to the permanency goal of unrelated adoption at this time?
I believe that there has been an appeal filed with the Fourth Circuit.
Is that the only barrier that you can think of?
Yes, Your Honor.
And then, of course, they'll have a waiting period after moving to this new placement, correct?
Yes, there will be the 6-month time period of being in the new placement.
Any specific reasonable efforts that Belong has made towards achieving the permanency goal for the boys?
Yes, Your Honor. We knew throughout the boys' case with us that the current foster home was not going to be their long-term permanent home. And as ordered by this court, we have been seeking a foster to adopt home that would be willing to adopt the children together. Belong placement found us a couple. We staffed with them and those didn't work out. But the most recent one was with Miss Bingham. And that initial staffing went very well because of Landon's unique needs due to his autism diagnosis. We proceeded strategically to have Shannon visit the children at their placement, to visit locally in the community where their foster home was. And then most recently, the two foster parents facilitated a pre-placement visit in her home in the Dallas area for approximately 5 days. It was our intent that if that went well, that we would proceed with trying to get the boys placed there as quickly as possible. So the only thing that's been delaying us getting into their potential forever home has just been moving slowly and carefully to be sure that it was a good fit and that Ms. Bingham would be able to handle Landon's unique characteristics. But by all reports, that recent visit on the 15th of February that began February 15th went well. And there are plans in place for one more visit coming up at the beginning of March with the boys just to go ahead and stay there at that time.
Okay. Mr. McKeska, questions for Ms. Nix?
No, Your Honor.
Ms. Savage,
No questions, Your Honor.
what are your thoughts on things?
I'm really excited that we found a placement for both the boys. It took a while because Landon's got some pretty significant needs. We wanted to make sure we found the right place. We had found one where we did a visit, didn't work out. But this Miss Bingham seems to be really committed to them. The visit this weekend went really well. The boys were sad to leave. She was sad to see them leave. They haven't had a connection like that with anyone other than the foster family that they've been with. And I know that foster family is supportive of them going here. I think if she's ready, I think the boys are ready. This has been a very, very long, drawn out process for them. And I think with Landon's needs, the back and forth could be very confusing for him. I think it would be better for him to be in one place and start a routine so he can get used to that, because that's beneficial for any small child, but especially with his autism, it's going to be super helpful. So I support, the plan to move them on March 1st.
Okay, thank you. Ms. Curry?
Yes, CASA has visited with them, and because of the support of the foster parents at this time, they are very, very impressed with the potential placement with Ms. Bingham. And Ms. Bingham just seems very excited to be part of the children's life. And I believe that she's got all the services lined up, and as soon as she receives them, they'll instigate the beginning of the services that especially Landon needs. So yes, we're definitely in support of this placement.
Thank you, Ms. Curry. For the purposes of the permanency review after final order, the court finds that there's no Indian child heritage in this suit, that the permanency goal of unrelated adoption is in the best interest of the children, that both children are up to date on their medical, dental, and vision checkups. They're not receiving any special services at this time. The ABA therapy is in progress as far as a wait list goes. Court finds that this current placement is the least restricted placement available. It's safe and appropriate and meeting the needs of the children. However, it is in the best interest of the children to transition to the foster home of Shannon Bingham beginning March the 1st, 2024. The court approves that plan, finds it's in the best interest of the children. Court will make a finding that there was a pre-placement visit that went well. Court finds that the major barriers to adoption at this time, one is the appeal that's been filed by Mr. Lauchese, and the other would be the waiting period post-appeal. Hopefully they run concurrently the 6 months in the adopted placement. So hopefully we can knock both those out at the same time. The next hearing that we would have would be a permanency review after final order for July 25th, 2024 at 10 a.m. July 25th, 2024 at 10 a.m. And by all intents and purposes, it looks like we're going to need that hearing at this time. So if the parties feel the need in between now and that hearing to have a staffing on this case, please do so. It sounds like you're all working together pretty well on it, so I'm not going to make any orders as to that. But anything I failed to address, Mr. McKeska?
No, Judge.
Okay. Thank you all for your time and your service. Mr. Bingham, thank you for what you're doing. And if nothing further, all parties are excused.
Your Honor, one quick thing. Miss Bingham does have a trip planned for Nevada, New Mexico area. And so I just want to get
Grand Canyon.
the Grand Canyon. And so I just want to get that court approval while we're all here. It's just easier.
I think, what's the date of it?
Spring break. So like 3 weeks.
Okay. Yeah, as long as everything goes according to plan, and there's no hiccups in between now and then, that travel is approved.
And then I wanted to verify we have birth certificates for both the boys. That's just been an ongoing problem in some of my cases. So, Miss Nix.
Don't believe that we have birth certificates. We have birth verifications. That is sufficient for adoption. But I'll
Thank you.
double check on that. Since the case has transferred to Ms. Burkholder, I think that was one of the requirements before I could transfer it, as I had to verify. So I do believe we have the verification. So
Let me go ahead and just add on that note a couple of things into the order, Mr. McCusker. I want to make sure we get the redaction and the HESIG ordered. And then I'm going to order belongs to check on birth certificates to see where we are, see if there's something that can be started at this time so that that doesn't delay us when it comes time for an adoption. Okay. Thank you all for your time and your service. Have fun in Arizona. All parties are.
Thank you.
My understanding is the parties are asking for a reset.
Yes, Your Honor, I am asking for a pre-adversary mediation. And I would ask, since my client is on this call and my phone is gone kerflooey because of the AT&T thing, I'd asked after this hearing if I could just confer with her real quick in a breakout after we're done.
All right, is your client Bernadette there?
Bernadette, yes, she is, Your Honor.
All right, Ms. Constante, I'm going to ask you not to vape in court, okay? All right, and Mr. Taylor's not here, correct?
That's correct, Your Honor.
Okay. So then I'll allow Ms. Constante and Ms. Hellrum to talk after the hearing. The only thing is our next Medina docket, we're having a visiting judge. Judge Morris is going to be covering for me. Can you guys mediate this within the week?
I'm hopeful. I think we could try. I just need to get additional information, Your Honor, that I was not able to get last night because I had talked to my client so late.
Okay, well, I have an availability to have the adversary hearing on the 28th. That's 6 days. So if you can get your mediation done, then we can get that setting on the 28th.
That works for the department.
Okay, what time is the setting, Your Honor?
The only other thing I have that day is another 262. And Ms. Greenlee, what time would this setting be?
10:30.
I think I can do that.
No objection.
No objection, Your Honor.
With that, then, Ms. Kyler Green, would you please begin the announcements?
Yes, Your Honor. Good morning. Emily Kyler Green, attorney for the department.
Desiree Flores, FBSS supervisor.
Javier Hernandez, the family-based caseworker.
Tracy Kidnap, permanency supervisor, observing.
Ona Powell, belong permanency specialist, observing.
Cecilia Howard on behalf of the mother. She is not present, Your Honor. However, she was present at the last hearing that was reset to today, and she was in mediation and actively participated in the mediated settlement agreement. So for purposes of this hearing, I am ready.
Lana Pearsall, attorney for the father who has not been served and is not present, and I'm ready.
Marco Cabrera, attorney at Light, ready.
All right, Ms. Pearsall's announced not ready. Her client hasn't been served, wasn't party to the agreement. That's granted. Court will make no orders as to Rodney Taylor today. Ms. Kyler Green, I don't know if you need to, I've got share screen available.
Yes, Your Honor.
You want to go ahead and set forth the terms and conditions of the agreement, please?
I will, and I'll share my screen. Your Honor, this is not a file stamped copy. It's my understanding that our mediator, Mr. Saldivar, has sent it in to be filed, but it hasn't yet been accepted by the filing system.
Okay. Yes, ma'am.
Non-revocable and binding Rule 11 agreement on 227. All parties agree to the following. Parties agree that the terms of this Rule 11 agreement are in the children's best interest. Number 2, the petitioner, Department of Family and Protective Services, shall be referred to as DFPS. Number 3, all parties agree that at the 262 hearing set on 2/28/2024, DFPS will be named as temporary managing conservator, and respondent mother, Bernadette Jacqueline Constante, will be named as temporary possessory conservator. Number 4, the parties agree that the respondent mother, Ms. Constante, will participate in the following services: an OSAR evaluation and follow recommendations, participate in random drug testing, complete a psychological evaluation and follow recommendations, be evaluated by MHDD and follow all recommendations regarding mental health and medication management, maintain safe and stable housing, maintain employment, allow DFPS/belong and the ad litem access to the home, and complete a parenting course. Number 5, the parties agree respondent mother, Ms. Constante, will have weekly visitation with the children for 2 hours in Seguin, Texas at an agreed location. The parties agree that Ms. Constante will give DFPS belong 24-hour notice that she will be attending her visitation for that week. Failure to give 24-hour notice before the visit will result in the visit being canceled. Number 6, the parties agree that an expedited home study will be conducted on the home of Ms. Cheyenne and Nicholas Hines. Number 7, the parties agree that the requirements for DFPS to make reasonable efforts to avoid the removal of the children have been met as specified in the removal affidavit and comply with the Texas Family Code. Number 8, the parties agree the use of electronic signatures shall have the same legal effect as original handwritten signatures. And below, Your Honor, are the signatures.
Mr. Hernandez, do you believe that this agreement is in the best interest of the children?
Yes, Your Honor, I do.
And is all the information in your affidavit, to your knowledge, as of today, still true and correct?
Yes, Your Honor, it is.
You believe it's in the best interest of the children to be in the temporary managing conservatorship of the department?
Yes, I do.
And you believe that all reasonable efforts were made to avoid a removal in this case, and all reasonable efforts were made to allow the children to return home if they could not go home?
Yes, Your Honor, I do.
All right, thank you. Do you believe the current placement of the children is safe and appropriate, meeting their needs?
No, Your Honor.
And do you believe it's in the best interest of the children to be, where are they placed right now?
They're currently placed at Legacy Ranch.
Okay, you don't believe it's in their best interest to remain there?
No, Your Honor.
All right, have the parties talked about where they're going to move to?
Hopefully with Miss Cheyenne.
Okay, that's the only other place available at the moment?
Yes, Your Honor.
Okay. All right, so now I understand. You've got them at Legacy, you don't want them there anymore, but you don't want to move them unnecessarily before we can get with Cheyenne, which is the purpose of the expedited home study.
Yes, Your Honor.
All right, you believe all that's in the best interest of the children?
Yes, Your Honor, I do.
Okay. All right, Ms. Halrung, you believe this agreement's in the best interest of the children?
I do, Your Honor. We had a pretty lengthy mediation. My client is in agreement. I would ask that the court order the belong to get with my client to schedule a visit this week. She's not seen the children in about 2 or 3 weeks. Additionally, Ms. Cheyenne Hines was present for the mediation, and I believe that the department received all the information that they needed to begin the home study. So I would just ask that that be expedited. Thank you.
And you feel as if you had a good conversation with your client about what's expected of her and that she understands the agreement that she's entered into?
Absolutely, Your Honor. It was a pretty long mediation, so yes.
Okay. And Ms. Pearsall, again, is not a party to the agreement, and her client has not been served. So do you, Mr. Cabrera, do you believe that this agreement's in the best interest of the children?
Yes, Your Honor, I do. I've met with the children at Legacy Ranch. They're being taken care of as well as they can there. It's what you would expect from a shelter. You know, they're fed, they're kept warm, they're housed, they're taken to school. It's not the greatest. So I would hope that things work out with the home study with Ms. Han, and also ask that it be expedited. One of the things that we negotiated most about was visitation. The children did ask for increased visitation with their mother, and that was one of the important points of the order. So I do believe that is also in the children's best interest. As far as how they're doing, they seem to be doing okay. Journey seems to have some speech issues that I'm hoping can be addressed with a CANS assessment.
Okay. Thank you, Mr. Cabrera. Anything further from anyone else before I make a ruling?
Well, Your Honor, I just wanted to let the court know that the process of the home study has already is already well on its way, and it's I think it's already being sent up. We spoke with the individual, Ms. Hines, yesterday at length and got all the parties of the home's name, so that's it's already being expedited.
Okay.
And Your Honor, I know you granted mine already, and I obviously agree with that ruling, but I did want to point out that Mr. Hernandez has done an amazing job attempting to locate his father. And he's really gone above and beyond. And even though he hasn't been successful, I really do think he needs some credit. The amount of work he's done to try to locate him is like just truly outstanding. So I wanted that noted.
Thank you. Good job, Mr. Hernandez. I appreciate you making that effort. It's helpful in these cases.
Thank you.
You're welcome. And thank you for pointing that out, Ms. Pearson.
Thanks a lot.
You're welcome. All right, then. Based on the arguments and evidence of counsel, the court will find that Ms. Constante was served by a waiver on February the 20th, 2024. Mr. Ernesto Rodriguez is deceased, and Mr. Rodney Taylor has not been served and is not a party to this agreement or the temporary order. Court finds that the parties mediated this case and that the mediated settlement agreement of the parties is in the best interest of the children. Court will adopt and approve the mediated settlement agreement of the parties. Court will find that it's in the best interest of the children to name the Department of Family Protective Services / Belong as the temporary managing conservator of the child, and the mother, Miss Bernadette Constante, as the temporary possessory conservator. Court finds that there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the children caused by an act or failure to act with a person entitled to possession, and for the children to remain in the home is contrary to the welfare of the children. Court finds the urgent need for protection required the immediate removal of the children, and reasonable efforts consistent with the circumstances and providing for the safety of the children were made to eliminate or prevent their removal. And reasonable efforts have been made to enable them to return back home, but there's a substantial risk of continuing danger if the children are returned home. Court finds that the current placement of the children is safe and appropriate, but not in their best interest to remain in. So the court's going to order an expedited home study on Cheyenne and Nicholas Hines. As Ms. Kyler Green pointed out, she believes it's already in process, but because the parties agreed to an expedited home study, that's the order of the court. Court finds that Ms. Constante shall participate in the following service and OSAR and follow all recommendations, random drug testing, psychological evaluation, and follow all recommendations, an MHDD evaluation and follow all recommendations. She is ordered to maintain safe and stable housing. She is ordered to maintain gainful employment and to allow the department / Belong and the attorney ad litem access to the home, and also to complete a parenting course. Court finds it's in the best interest of the children for the mother to have weekly visits for 2 hours in Seguin at a location agreed upon by the parties, and that is with 24 hours notice. If she fails to give 24 hours notice, the visit shall not occur. And as part of the agreement, the parties agreed to stipulate that the department had made reasonable efforts to avoid the removal of the children, and Mr. Hernandez also testified to that fact. We're going to be back for a status hearing on April the 9th, 2024 at 9 a.m. April 9th, 2024 at 9 a.m. And I have to admonish the parents. The state of Texas gives parents in CPS cases 12 months to demonstrate you can provide a safe, stable, violence and drug-free home for your child. If you cannot do so, your rights to your child are subject to restriction as they are now or termination. If you please put that in the order. And then I also want to find at this time that because I don't have the ability to question Ms. Constante or Mr. Taylor today, or can make no further findings as to indigency.
Ms. Greenlee, can you let the court know he's frozen?
I'm sending him a message now.
Okay, good. Thank you.
Well, that was fun. I'm not sure what happened there. But I'll find for the purposes of this hearing that they are both indigent and will continue the representation of the attorneys through to our status hearing. Ms. Kyler Green, is there anything I failed to address?
No, Your Honor, thank you very much.
Your Honor,
Okay.
I do have one question. I know we did talk about the services and the mediation. but it may benefit, given my client's mental health issues, to have a family group conference if we could get that ordered.
Yeah, and I'm glad you brought that up. I know you already set up plans for the mother, and I understand father hasn't been served yet. So I think sometime between now and the status hearing, that would be a good idea, especially if you can get Mr. Taylor served. At least Ms. Pearsall can participate in that and try to convey that information to him. So I will order a family group conference to occur between now and the status hearing, and I'm going to defer to the parties on when to schedule that based on what's going on with the case.
Yes, Your Honor, thank you.
You're welcome. Anything else? Okay. Well, thank you all for your time and your service. Again, I do apologize for the technical difficulties this morning. I'm sorry it took so long for me to get it figured out, but I appreciate your patience.